Dear ladies and gentlemen, please allow me first of all to join in thanking the organizers. This is such a wonderful conference, and after all these times of COVID-19 restrictions, it is a particular pleasure to be on site and to be back in this true, real academic discourse. As we have already heard, As we have already heard today, the ICC statute assumes that it is the prime responsibility of the national states to take up the fight against impunity against international crimes. And in light of this, Germany, like many other states, adopted a code of crimes against international law, which allows for the national prosecution of genocide, crimes against humanity, war crimes, and meanwhile, the crime of aggression. Some states, including Germany, provide that these crimes can be prosecuted on the basis of universal jurisdiction, that is, regardless of the place of commission or the nationality of the victim or of the offender. However, dealing with crimes that bear no relation to the adjudicating state and which were committed in a different social and cultural context poses a huge challenge for the judiciary. The taking of evidence and the restriction of events that happens thousands of kilometers away from the court is complex and time-consuming. The gathering of evidence is hampered by cultural and linguistic barriers. Making criminal justice systems fit for the crimes against impunity for gross human rights violations, however, is not only a question of effectiveness. It may also require rethinking and readjusting fundamental concepts of criminal law and justice. Allow me to illustrate this by a recent example from Germany. In April 2020, the Higher Regional Court of Koblenz began a trial against 2 former members of the Assad regime for crimes against humanity. It is the first criminal trial worldwide on state torture in Syria, and it therefore attracts a large amount of public attention. In particular, Syrian journalists, Syrian NGOs, and victims of the Assad regime want to follow and monitor the trial. This is hampered by the fact that the trial is conducted in German language and that due to COVID-19 restrictions, whispered interpreting is not allowed. The defendants who do not speak German neither, however, are provided with simultaneous interpretation into Arabic, which is transmitted via earphone. The Syrian journalist and some victims, therefore, ask for access to this official court interpretation. The Higher Regional Court of Stuttgart denied this request. It stressed that German is the language of the court and that victims and media representatives therefore do not have the right to provide it on state resources with an interpretation. Upon a constitutional complaint by the journalists and the victims, the German Constitutional Court ordered in a preliminary decision that in order to safeguard the fundamental right of the press, to give all journalists an equal and real opportunity for reporting on court proceedings, and to meet the great need for information, especially among the Syrian population, accredited media representative with a special interest in independent reporting on the Koblenz trial must be enabled to follow the trial in Arabic, for example, by giving them access to the simultaneous court interpretation. This, according to the German Constitutional Court, does not apply for non-journalists who, like victims, wish to attend the trial for private reasons and may inform themselves on the court proceedings from other sources. I would like to use this decision as an opportunity to initiate a more general discussion on the function, scope, and content of the principle of a public trial and the national prosecution of international crimes. From a human rights perspective, the principle of open justice is closely linked to the right of a fair trial. It protects the defendants against the administration of justice in secret. The public serves as a kind of watchdog which controls the judiciary. It ensures that all procedural safeguards are respected and that all relevant legal and factual circumstances are duly considered. At the same time, open justice is an important tool for democratically legitimizing the judiciary. This is particularly true for states in which judges are not voted into office. In such cases, the only way to ensure that judicial power, which is naturally a form of state power, is derived and controlled by the people, is making judicial decisions part of the public discourse. The people, as a sovereign, have the right to be informed about the cases brought before the courts, the events in the courtrooms, the conduct of the proceedings, and the decisions taken by the judges. Open justice enables the general public to develop and express informed opinion on legal policy matters and, if need be, demand a change in law or legal practice. Last but not least, okay, something happened. Is it my presenter? Ha, it's back. Last but not least, open justice contributes to the realization of the purposes of punishment. In line with the expressive theories, I suggest that criminal convictions have a communicative function. By committing a crime, the perpetrator expresses that he is not bound by the violated norm or that the norm is invalid at all. The criminal conviction is the communicative counter-reaction of the community. It stresses that the norm is valid and has to be obeyed. Through the imposition of punishment, the society thus expresses its disapproval of the person's criminal conduct. This message is first of all directed at the defendant himself, who is personally blamed for having committed a criminal wrong. Secondly, the criminal conviction also sends a message to the general public. It reaffirms that the violated norm is socially necessary and, although ignored by the defendant, valid and must be obeyed, and that also in future norm violations will not be tolerated. Thirdly, the criminal conviction also sends a message to the victims. It confirms that they have been wronged and that the act has unduly infringed on their rights and that the offender is personally responsible for the harm they suffered. In this sense, a criminal conviction is a kind of solidarization of the public with the victims, which may help them in overcoming the crime and its consequences. If, however, a criminal conviction is a communicative act directed at the society at large and the victims in particular, criminal trial must necessarily be conducted in public. Otherwise, the message contained therein cannot reach its addressee. The principle of public trials thus is democratically necessary and, from the view of penal theory, sensible. This leads us to the question of who is the public. Roughly speaking, one can distinguish between three levels of publicity. The first refers to the courtroom itself. Publicity in this meaning merely requires that everyone has the right to enter the courtroom and attend a court hearing. As the number of spectator seats in courtroom is limited, this also necessarily leads to a very limited form of publicity. On the second level, the media public. Some seats in the courtroom are reserved for journalists who monitor the trial and report on the proceedings. They function as a kind of information multipliers who inform the broader public about the work of the judiciary. In its broadest form, Publicity is achieved by audiovisual recording of the trial, which can later be seen on television or streamed on the internet. Obviously, the third form of, let's call it, universal publicity may easily conflict with the right of the defendant, in particular his personal right, his right to informational self-determination, and the presumption of innocence. Okay, what does it mean for the domestic, decentral enforcement of international criminal law? At the outset, national prosecution concerning international crimes are normal national proceedings. They are conducted in accordance with the requirements and specification of the applicable national procedural law. Nevertheless, they are special in two regards. First of all, they deal with an international matter. The accused is held responsible for having violated an international norm. Second, if the crimes are prosecuted on the basis of universal jurisdiction, they are in no way linked to the adjudicating state. The latter seriously affects the ability of the public to exercise its control function. Naturally, control by the public does not require that the spectators in the courtroom are legally educated. Rather, open justice aims at initiating a discussion to find out if the law and its application in a concrete case are based on a social consensus or an expression of shared values. This, however, requires that the public can understand and evaluate the circumstances of the case and the behavior of the persons involved. In criminal proceedings, it is necessary to put the crime, its origin, its dynamic, and its consequences into the respective social cultural contexts. This is particularly true for international criminal law, where the single acts are no isolated acts, but committed in a broader context, for example, as part of a widespread attack against the civilian population. If the human rights fundament of the open justice principle wants the public to ensure that the judiciary has duly considered all relevant legal and factual circumstances, this is possible only if the public has a certain closeness to the subject matter of the trial. To return to my initial example, the German public will probably lack the background knowledge necessary to assess incidents in a Syrian prison setting and to critically accompany the hearing of evidence concerning faraway events. Effective control of the judiciary is controlled by a public linked to the case. For the democratic legitimation of the judiciary, however, only the national discourse counts. The exercise of state power must be traced back to the respective sovereign, the people of that state exercising jurisdiction. In Koblenz, the judgments are rendered in the name of the German people. Nevertheless, the demands of international law call for an internationalization of the public discourse accompanying universal prosecution. It is meanwhile commonly accepted that the competence to establish criminal jurisdiction is limited by international law. Roughly speaking, the exercise of jurisdiction generally presupposes a real link or a genuine connection between the case at hand and the state claiming jurisdiction. Classical and well-established factors, which, as a rule, legitimize the exercise of jurisdiction, even if this affects the interest of other states, as the place of the offense, the nationality of the offender or the victims, or the endangerment of essential state interest. The principle of universal jurisdiction makes an exception to this rule and allows for the prosecution of certain crimes, even in the absence of a legitimizing link. This is justified only if the crimes in question harm universally recognized legal interest, namely fundamental human rights, as well as the peace and well-being of the world, and therefore are, as the ICC statute puts it, of concern to the international community as a whole. In this way, the state exercising jurisdiction does not act in its own interest, but on behalf and as a representative of the international community. If, however, the national judiciary enforces a right to punish of the international community, it seems only logical that the legal discourse initiated and associated with these proceedings must be internationalized as well. International criminal norms claim universal validity. Ensuring a more or less equal application of the core crimes provision presupposes a transnational discussion on the application, scope, and interpretation. To give another example from the German practice, in 2017, the Federal Court of Justice held that the war crime of outrages upon personal dignity can also be committed against dead persons. This interpretation was discussed at the international level and adopted by foreign courts. And this discussion is an important mechanism for the homogeneous development and standardization of international criminal law. And also, it is commonly accepted that international law allows, as a matter of principle, for the universal prosecution of international core crimes, any extension of national criminal jurisdiction which cannot be based on legitimizing links, risked conflicts with the principle of non-intervention. This is also more true as the right to establish jurisdiction is limited under international law by the prohibition of arbitrariness. The exterritorial application of national criminal law must neither be unreasonable nor disproportionate. The publicity of universal prosecution therefore is important to allow the territorial state to monitor the trial and to control that the adjudicating state respects its sovereign interest. To open up proceedings on international crimes to the international public, this enhances their legitimacy vis-à-vis the international community in general and the territorial state in particular. This is confirmed by teleological considerations. As the Tribunal for the former Yugoslavia has repeatedly pointed out, convictions for international crimes are a form of retribution duly expressing the outrage of the international community at these crimes. The sentence may explain the condemnation of the international community of the behavior in question and shows that the international community was not ready to tolerate serious violation of international humanitarian law and human rights. The ICTY thus attaches particular importance to the expressive function of punishment. And if international criminal law claims universal validity, and is exactly this claim of universality which is rejected by the offender, then the communicative counter-reaction of the community must also be heard at the international level. It must clarify that the violated norm is valid and has to be obeyed by everyone in every state of the world. And in this communicative discourse, the territorial state and the society directly affected by the crime play a particular important role. International crimes are committed in a collective context, which is dominated by a state or state-like authority, which either directly organize or at least tolerate the crimes committed. This means that not only the individual perpetrator, but also the state involved ignores international law norms. In the Koblenz trial, the judges will inevitably touch upon the question if the Syrian state has violated the international prohibition of torture. The criminal conviction of members of the Syrian regime also sends a message to the Syrian state that the international community, here represented by Germany, will not tolerate massive violation of human rights and absolute prohibitions of international law. At the same time, the conviction acknowledges the harm suffered by the victims in a very special way namely by pointing out that the victimization took place in a broader systematic context, and by implying that not only the individual perpetrator, but also the state involved is responsible for the injustice done to them. After what has been said so far, international law and penal theory call to open up universal prosecution to the international community and the international discourse. What does it mean in concrete terms? Firstly, in proceedings based on the principle of universality, some seats in the courtroom should be reserved for journalists who have a special interest in the alleged crime and report on the proceedings in and for the affected society. They ensure that the proceedings become known in the territorial state and among the victims who cannot travel to the seat of the court. They thus have a particular important multiplier function. Secondly, these journalists should be granted access to the official court interpretation. This makes it easier for them to follow the proceedings and will finally improve the quality of their reporting. Contrary to the view of the German Constitutional Court, this right should not be limited to accredited journalists. In failed or dictatorship states, there is often no free and independent press. Rather, it is NGOs that monitor proceedings and report about the trial on their blogs. Thus, it seems more convincing not to focus on a formal status of the person, but on whether she actually fulfills a multiplier function vis-à-vis the territorial state or the affected society. Thirdly, victims should also be granted the right to access the official court interpretation. To argue, as the German Constitutional Court has done, that they may inform themselves on the course of the proceedings from the press ignores that they are closely linked to the crime and directed effectively by the norm violation. This in turn means that they are entitled to a very prominent role in the communicative process following the crime. One should even consider to grant victims an independent right to interpretation, which becomes relevant in case the perpetrator, the defendant, speaks German and does not require the assistance of an interpreter. Acknowledging the suffering of the victims and respecting their dignity requires at the minimum that they are not made an object of the trial, which in turn presupposes that they can understand and follow the trial and see justice done. In this vein, for example, the Victims' Rights Directive of the European Union recognizes a general right of victims to understand and be understood. Fourthly, decisions of national courts concerning the interpretation and application of international criminal law should be translated ex officio into English, the lingua franca of international criminal law. This ensures that they can be discussed at the international level and contribute to a harmonized development of international criminal law. And last but not least, and this is at least from a German perspective, probably the most controversial aspect of my outreach proposals, one should consider recording domestic trials concerning international crimes and making them available on the internet. This is common practice for the international criminal tribunals that use web streaming services to broadcast their sessions with a 13 minutes delay. The 13 minutes give the registry the opportunity to redact the recording if necessary to prevent the disclosure of confidential information. Such a broadcasting ensures that the criminal trial and its communicative message can gain international attention and reach the affected society. This is particularly important if one puts universal prosecutions into their broader context. They are, or should at least aim to be, part of a transitional justice process by which the affected society attempts to come to terms with the legacy of large-scale past abuses. For this transitional justice process, it can be of great value if the affected society can at least follow relevant proceedings via video stream. Naturally, such a broad, potentially worldwide distribution of criminal trials must be balanced against the personal rights of the defendants. However, if the court itself records the proceedings, it can make it as objective as possible without dramatic cuts or summaries, which are typical for commercial court TV shows. And arguably, the interference with the defendant's rights can be outweighed by the gravity of the crimes charged and the heinous consequences. All in all, universal prosecution of international crimes are meaningful only if combined with a broader outreach program. They must be opened up to all victims, the affected society, and the international community. Or in other words, the concept of open justice must be given an international dimension. Thank you very much.